Welcome to the Deep Dive, where we take your source material and pull out the essential insights you need to be well-informed. Today, we're doing a deep dive into a really critical and complex area: non-discrimination, equality, and the rights of women. We're working from a fascinating set of documents. And a special note before we begin: these insightful documents have been made available by the University of London for educational purposes, and we want to give them full credit. We really appreciate the opportunity to explore them together.
Absolutely. And this particular deep dive, it's specifically designed to help you navigate this complex topic. It's, tailored to help understand the core concepts, see how they apply in the real world, and importantly, help you prepare if you're studying this area or perhaps facing exams.
Exactly. We want this to be a really valuable resource for your learning journey.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
We wish you the very best of luck with your studies and any exams you might be preparing for. Okay, so our mission today is pretty comprehensive. We want to cover the entire scope of the provided document, leaving no stone unturned, really focusing on the core ideas, the key international treaties, and crucially, the real-world challenges in protecting women's rights.
That's right. We'll be looking closely at the concepts of discrimination and equality first, then how major human rights treaties address these. We'll also examine the specific focus on women's rights, why it's needed, and dig deep into the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. We'll cover its enforcement mechanisms, criticisms, and look at specific case studies from around the world to see how this all plays out.
Okay, sounds like a solid plan. Let's jump in and unpack this. Let's start with the absolute basics right there in the document. Why do we actually have legally protected human rights in the first place? What's the fundamental rationale?
Well, at its very core, it boils down to inherent human dignity. The idea is that simply by being human, by being a person, you are entitled to certain fundamental rights. These aren't granted by anyone. They're inherent. Things like not being tortured or having the right to express yourself, the right to work or education. Basic stuff, really.
Right, that seems pretty foundational. But the document quickly moves on to ask why these rights get violated. And it makes a pretty strong claim. Discrimination is always, or almost always, part of the reason.
Precisely. That's a key insight. Discrimination, which is based on some perceived difference between people, inevitably leads to unequal treatment. Think about the example the document gives. An ethnic minority group being treated less favorably than the majority when it comes to things like housing, schooling, or getting a job. That difference in treatment is discrimination.
And the document lists quite a few grounds for this kind of discrimination: race, disability, nationality, age, caste, religion, loads of examples. But it also makes a really crucial distinction. Not all different treatment is necessarily bad or prohibited discrimination.
That's a very, very important point. You have to distinguish. Treating, say, a 4-year-old differently from an 18-year-old when it comes to the right to marry, well, that's objectively justifiable, isn't it? The law sometimes needs to draw lines based on relevant differences. Now, societies might differ on exactly where those lines are drawn, like should the minimum age for marriage be 16 or 18? That can vary. But the principle holds. Some differential treatment is okay if it's objectively justified.
Okay, so differential treatment can be acceptable if there's an objective justification. But then the document raises a more contentious point: which grounds of discrimination should actually be prohibited by law. It's not always agreed upon.
Yes, exactly. And the example of caste discrimination is highlighted here. It's clearly practiced in some societies, deeply affecting things like employment, education, housing access. But caste, as a specific ground, is not expressly mentioned in any universal human rights treaty, though it can sometimes be linked to the ground of descent, which is mentioned in the Race Convention. But caste itself isn't explicitly listed everywhere.
And it mentions the UK example where there have been, extensive efforts to prohibit caste discrimination by law, but these have actually been unsuccessful so far. It really shows how much contention there can be over which grounds get legal protection.
And this is where the law evolves, isn't it? The document uses sexual orientation discrimination as a good example of this evolution. It's widespread, but it's really only in the last 20 years or so that law, both domestically in many places and through international interpretation, has started to explicitly prohibit discrimination on this ground. Shows how these lists aren't static.
Okay. Before we dive deeper, the document defines a couple of key terms that are easy to confuse but really important to keep separate: equality and non-discrimination.
Yes. Absolutely crucial terms. Non-discrimination is essentially about preventing negative treatment. It's about not treating people less favorably than others based on prohibited grounds like sex, race, religion, and so on. It ensures a basic level of fairness. Equality, though, is about people being treated equally. But, and this is where the famous Anatole France quote in the document comes in, formal equality can be misleading. You know the quote. The law, in its majestic equality, forbids rich and poor alike to sleep under bridges. It sounds equal on paper, but the reality is vastly different because of underlying inequities. Formal equality can mask deep inequalities.
That quote really sticks with you. It makes you think about what equality really means in practice. The document then distinguishes between two important notions of equality: equality of opportunity and equality of outcome.
Right, let's repeat those because they're central. Equality of opportunity and equality of outcome. These concepts are often debated. Broadly speaking, equality of opportunity means everyone gets a fair shot, like a job being open to everyone, qualified, regardless of their age, gender, or race. The starting line is level.
And equality of outcome, what's that about?
Well, that's a bit more ambitious and often more controversial. It's about trying to ensure that people actually end up in similar situations, regardless of their background. So, for example, aiming for similar educational results between different groups, or ensuring that professions like judges or politicians actually reflect the diversity of society in terms of gender, race, etc. And the document points out something interesting. Achieving equality of outcome might actually require what looks like discrimination specifically, positive discrimination or affirmative action, to actively help those who start from a disadvantaged position.
That distinction is really key. Equality of opportunity versus equality of outcome. Let's just restate those one more time for clarity.
Yes, critical for understanding policy debates. And two final terms defined here are direct discrimination and indirect discrimination. Let's repeat those two. Direct discrimination and indirect discrimination.
Direct discrimination seems pretty straightforward from the example given. A job advertised only for men. A qualified woman applies. She's denied because she's a woman. That's direct. The reason for the different treatment is the prohibited ground itself.
Exactly. And the document is clear. Direct discrimination cannot be justified. There's no legitimate reason for it.
Okay. And indirect discrimination.
This one's a bit trickier. It happens when a rule or requirement seems neutral on the surface, applying to everyone, but the outcome or effect is discriminatory for a particular group. The example is that job requiring applicants to be 2 meters tall and weigh over 100 kilograms. Now, that rule applies to men and women equally, but in reality, very few women would meet those physical criteria compared to men. So the effect is that almost all successful applicants would be men. The effect is discrimination against women, even if the rule didn't explicitly mention gender.
So that's indirect discrimination. A seemingly neutral rule, but with a discriminatory effect. And the document says this kind of discrimination can sometimes be justified.
Yes, that's the key difference. If that physical requirement being 2 meters tall, over 100 kilos, was genuinely necessary for the job, like if it involved extreme physical strength that only someone of that build could safely perform, then the criteria might be justifiable, even though it disadvantages women as a group. It has to be a proportionate means of achieving a legitimate aim.
Okay, got it. Direct discrimination can't be justified. Indirect discrimination can sometimes be justified if necessary and proportionate. These definitions are really important building blocks.
Right. So now that we've got those foundational concepts down, the document moves on to how they actually appear in international human rights treaties. It points out that pretty much every major treaty has some kind of equality or non-discrimination clause, but there's no single consistent way it's done. It varies depending on the treaty, when it was drafted, maybe later amendments.
Let's look at the big UN ones first. The ICCPR, the International Covenant on Civil and Political Rights, and ICESCR, the one on economic, social, and cultural rights. The document suggests the ICCPR has the most comprehensive approach for a general treaty.
Yes, it tackles it from a few angles. It has 3 main provisions that are relevant here: Articles 2, 3, and 26. Let's repeat those for clarity. Article 2, Article 3, and Article 26 of the ICCPR.
Okay, what does Article 2 say?
Article 2, specifically 2.1, is the general non-discrimination clause for the rights guaranteed within the ICCPR itself. It requires states to ensure those rights are respected and enjoyed without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. And notice the wording "such as" the document highlights this means the list isn't exhaustive, it's open-ended, allowing for other grounds to be included over time.
Okay, and Article 3?
Article 3 is specifically about gender equality. It's an equality clause, but it only applies to men and women, and it's limited to the enjoyment of the rights in the ICCPR. So, states undertake to ensure the equal right of men and women to enjoy all the civil and political rights in that covenant. Gender equality, but linked to ICCPR rights.
Right. Now, Article 26 sounds like it's different, potentially broader.
It is. Article 26 is really significant. It's a combination. It's both a non-discrimination and an equality clause. And crucially, it's not limited to the rights within the ICCPR. It's a freestanding right. It applies to any right recognized by domestic law in a state party. It says all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. It then prohibits discrimination by law and guarantees equal protection. Again, the grounds listed, such as race, color, sex, are examples, but those that are explicitly stated must be recognized. The Human Rights Committee, the body that monitors the ICCPR, has expanded on these in its general comments, particularly 18 and 28.
Okay, let's quickly recap the ICCPR's general clauses. Article 2, non-discrimination for ICCPR rights. Article 3, gender equality for ICCPR rights. And Article 26, standalone equality and non-discrimination for any right in domestic law. The document does note the Human Rights Committee's interpretation, especially of Article 26, has sometimes been controversial.
Moving over to the ICSCR, the Covenant on Economic, Social, and Cultural Rights, the approach is a bit different. It doesn't have a freestanding clause like Article 26 of the ICCPR.
Right, so no equivalent general right to equality and non-discrimination that applies broadly to domestic law in the ICSCR.
Correct. But it does have Article 2, which is a non-discrimination clause requiring states to guarantee the rights in this covenant without discrimination of any kind as to race, color, sex. And, similar to the ICCPR, it has Article 3, an equality clause specifically limited to ensuring the equal right of men and women to enjoy the economic, social, and cultural rights in the ICSCR. The committee monitoring the ICSCR, the CSER, in its general comments 16 and 20, argues that non-discrimination and equality are underlying principles for the whole covenant, even without that standalone clause.
Okay, now regional treaties show different approaches too. The document mentions the European Convention on Human Rights, ECHR, the American Convention, ACHR, and the African Charter.
Yeah, the ECHR covering Europe is described in the document as initially having a paucity of measures compared to the UN covenants regarding general non-discrimination. Its main clause is Article 14. Let's repeat that. Article 14 of the ECHR.
And what does Article 14 do?
Article 14 states that the enjoyment of the rights and freedoms set forth in the Convention must be secured without discrimination on the listed grounds, such as sex, race. The key thing here is it's not a self-standing right, unlike ICCPR Article 26. It only applies in conjunction with other rights guaranteed by the ECHR. You can't just claim discrimination under Article 14 alone, you have to link it to another convention right. The European Court has sometimes extended the grounds, but the document notes its relative conservatism in interpreting Article 14.
And so Article 14 basically says you can't discriminate when applying the other ECHR rights, but wasn't there a later protocol to address this limitation?
Exactly. Protocol 12 to the ECHR. It came into force in 2005, but only for those states that specifically accepted it. This protocol does establish a freestanding non-discrimination clause. It prohibits discrimination regarding any right existing in domestic law, making it similar in scope to ICCPR Article 26. However, the document notes that even with Protocol 12, the European Court still hasn't been particularly dynamic in its interpretation compared to the UN Committee.
So progress was made with Protocol 12 creating a standalone right, but maybe the interpretation hasn't been as expansive as some hoped. What about the American Convention on Human Rights, ACHR?
The ACHR, covering the Americas, is presented as placing more emphasis on non-discrimination right from the start. Article 1, titled Obligation to Respect Rights, states that parties undertake to ensure the rights in the convention are exercised without any discrimination for reasons of race, color, sex, language, religion, or any other social condition. While its legal effect might be similar to the ECHR's Article 14, linked to convention rights, putting it right there in Article 1 signals its fundamental importance.
And Article 1.2 of the ACHR explicitly stating person means every human being seems simple, but reinforces that universality principle clearly.
Yes, leaves no doubt. The ACHR also has equality clauses built into specific rights. Article 17 on family life, for example, requires states to take steps to ensure equality of rights and a fair balance of responsibilities between spouses.
Okay, finally, the African Charter on Human and People's Rights.
The document calls the African Charter potentially the most comprehensive of the regional treaties when it comes to general equality and non-discrimination. Article 2 is a fairly standard non-discrimination clause ensuring the rights in the Charter are enjoyed without distinction of any kind, such as race, ethnic group, color, sex.
And Article 3.
Article 3 seems to go further. It states, every individual shall be equal before the law and entitled to equal protection of the law. This sounds very much like a strong, potentially freestanding equality provision. The document notes it hasn't really been tested or examined in detail by the African Commission or court yet, but the potential is clearly there in the text.
So just comparing across the treaties then, ICCPR seems strongest generally with Articles 2, 3, and the crucial standalone Article 26. ICSCR is more limited with Articles 2 and 3 tied to its specific rights. ECHR was weaker initially with Article 14 linked to other rights, but gained a standalone right via Protocol 12, though interpretation is maybe cautious. ACHR puts non-discrimination right up front in Article 1 and emphasizes universality. And the African Charter looks comprehensive with potentially strong equality clauses in Articles 2 and 3, and all of them, in some way, prohibit discrimination based on sex.
Exactly. Which leads us to the next big question the document raises. Given that all these major treaties already prohibit discrimination based on sex and often have specific clauses about equality between men and women, why do we even need a specific category called women's rights?
That's a really fair question. If human rights apply to all humans and women are a half of humanity, shouldn't the general treaties be enough? Why single out women's rights?
The document tackles this head-on. It argues that women's rights, as a specific category, are necessary precisely to challenge and dismantle the systemic exclusion and disadvantage that women experience globally. They aren't separate from human rights, they are an integral part of them. But they are framed specifically to address the unique ways women are prevented from actually enjoying the universal human rights that everyone should have.
Okay, so it's not about women being fundamentally different and needing different rights, but about recognizing that the universal rights aren't being universally realized for women because of specific barriers and forms of discrimination they face.
Precisely. The focus is on making the universal promise of human rights a reality for women. The document links this to feminism, understood broadly as diverse movements promoting women's interests and connecting their rights to vital goals like ending poverty and achieving political empowerment.
And the document really drives this point home by citing the undeniable widespread data showing just how disadvantaged women are globally. This isn't just theory, it's reality.
Yes, it states surveys everywhere show women work longer hours, get paid less even for the same work, and do far, far more unpaid labor like childcare and housework. This creates a huge gender gap in accessing resources. Plus, things like reproductive health issues, higher rates of HIV/AIDS infection, these disproportionately impact women, especially poor women.
The link between empowering women and overall social and economic development is also strongly emphasized.
Absolutely. The document points out that countries with good development outcomes have consistently invested in things like universal healthcare and education, yes, but also, crucially, they've passed laws and implemented policies specifically aimed at ending discrimination and ensuring women can fully participate in society. The argument is simple. You can't reach your full potential as a country if you're only effectively utilizing the talents of half your population. Relying mainly on men limits everyone.
It gives a really powerful example. Improving women's education actually helps reduce child malnutrition more effectively than just improving food availability. And closing the gender gap in education helps reduce fertility rates and improve child survival rates, too.
These connections show just how vital focusing on women's rights is, not just for women themselves, but for the progress and well-being of entire societies.
The document then moves into specific examples of discrimination against women to illustrate these points more concretely. The first case study we get is about property rights for women in Kenya. It draws from a Human Rights Watch report called Double Standards: Women's Property Rights Violations in Kenya. Let's repeat that title, Double Standards: Women's Property Rights Violations in Kenya. The title itself is telling.
Yeah, this case study is really effective because it shows how women's property rights get tangled up in these complex national structures. You've got land law, historical factors like colonial legacies that often favored men owning land, and then a multiple, sometimes contradictory customary legal systems operating alongside everything else.
And the document points out that even when Kenya tried reforms after independence in 1962, the initial focus was more on dividing land fairly between different ethnic groups, not really addressing the gender imbalance within those groups.
Right. And while there have been some reforms in areas like succession and family law since then, that gender imbalance in who actually owns land is still a major, major issue. The complexity is highlighted by the fact that Kenya has, believe it or not, 5 different legal systems governing marriage: civil, Christian, Islamic, Hindu, and customary.
5 different systems. Wow. That sounds incredibly complicated for ensuring consistent rights, especially property rights, which are often tied to marriage or inheritance.
It is. It's a huge challenge. And while the Constitution technically prohibits sex discrimination, there are specific exceptions carved out for personal law and customary law. These exceptions often allow discriminatory practices against women regarding property to continue. The document mentions an ongoing constitutional reform process that might help, but it stresses that the failure to effectively protect women under the current system is a key reason they remain much worse off economically.
The statistics quoted from that Human Rights Watch report are pretty stark. Women's average earnings less than half of men's. Only 29% in formal wage jobs, most in the informal sector with no security. And 37% of households are female-headed, and a staggering 80% of those are poor or very poor, partly because they have such limited access to land.
Education gaps are also highlighted. Girls get less education at every level, and women's literacy is lower 76% versus 89% for men.
And the prevalence of violence is shocking. 60% of married women reported domestic abuse in a 2002 study. 83% of women reported physical abuse in childhood, 61% as adults. And only one shelter for battered women mentioned for the whole country.
The numbers are devastating. And then it details the land ownership gap specifically. Women do over 80% of the agricultural labor, often unpaid, and they're 64% of subsistence farmers, contributing about 60% of farm income. Yet women account for only 5% of registered landholders nationally. Let's repeat that. Only 5%.
Only 5%. That's a massive disconnect between their contribution to farming and their ownership of the land itself.
Absolutely. And female-headed households own less than half the farm equipment compared to male-headed ones. Rural women work nearly 3 hours longer per day than rural men. Losing land is particularly devastating for these women because they're so involved in agriculture but often lack other formal job options.
The document then zooms in on customary law. It explains this law comes from custom and practice, it's formally recognized in Kenya, and it's often specific to different ethnic groups.
And while customary law can change over time, the norms are often rooted in these really deep-seated customs that are just hard to shift quickly. The practice of wife inheritance is given as a particularly challenging example. Let's repeat that term. Wife inheritance.
Wife inheritance. Okay, so this practice, in some parts of Kenya, meant a widow could be inherited by a male relative of her dead husband. The document notes that, historically, this might have served as a form of social protection for widows who couldn't inherit land themselves, ensuring they and their kids were looked after by the extended family.
However, the practice involved these rituals, including cleansing the widow, sometimes through sexual intercourse with a social outcast, because of fears she was contaminated by her husband's spirit or something.
That's disturbing. And the document quotes women's rights advocates, saying women often felt they had to be inherited or cleansed just to keep any property and stay in their communities. It wasn't always voluntary, far from it.
Yeah, the women interviewed by Human Rights Watch had mixed feelings, basically saying they went along with it to keep their property and community ties, even though they didn't want to.
The document connects this to a broader point: how women, throughout history and in many societies, have often been treated almost like property themselves. And this discrimination in inheriting property under customary and religious laws isn't unique to Kenya at all.
It points to examples like male preference, primogeniture, and royal families, mentioning the UK finally changing this with the Succession to the Crown Act, 2013, and it gives examples from Jewish and Islamic inheritance laws as presented in the source material.
Yes, it specifies how Jewish law, according to the material, traditionally favored men. Daughters couldn't inherit if sons survived, the mother's family weren't heirs, and a husband inherited from his wife, but not the other way around.
And Islamic law, broadly speaking, dictates daughters inherit half the amount sons inherit. The example given is, a father dies with 3 sons and 2 daughters. Each son gets a quarter of the estate, while the 2 daughters have to share a quarter between them.
These specific examples from Jewish and Islamic law, as laid out in the document, really highlight how endemic these issues of discrimination against women in inheritance can be.
Other examples mentioned relate to women being seen as unclean or impure during menstruation, sometimes preventing them from entering religious places. This kind of connects back to that cleansing idea from the Kenyan example, showing how notions of purity and impurity can be used to exclude women. Building on that, the document presents another really difficult example, this time from a 2016 BBC report about a practice involving a hyena in southern Malawi. Let's repeat that term, hyena.
This refers to a man who is hired for ritual sexual cleansing. The document describes it as a traditional practice in some remote areas, something the village elders apparently don't see as rape, but as a necessary ritual.
And the document gives examples of when this is required. A widow has to sleep with a hyena before she can bury her husband, or a woman has to do it after having an abortion.
And, most shocking perhaps, is the practice involving teenage girls. After their first menstruation, they are made to have sex over 3 days with a hyena as a rite of passage into womanhood.
The belief underlying this, according to the report, is that refusing the ritual could bring disease or even death upon the girl's family or the whole village. The hyena interviewed, a man named Eric Aniva, claimed he preferred older girls but admitted sleeping with girls as young as 12 or 13.
He also reportedly boasted that the girls enjoyed it, but the document contrasts this sharply, quoting girls who expressed aversion, saying they only do it for their parents to avoid bringing harm to their families.
The practice is often organized by older women, female elders, who teach the girls about being wives and pleasing men. This cleansing is the final step, arranged by the parents. The elders justified it as preventing infection and training girls.
A critical, horrifying point highlighted is that sex with a hyena must never involve condoms. The belief is that the hyena is chosen for his morals and somehow can't have or transmit HIV zets.
But the reality exposed by the report was that this particular hyena, Eric Aniva, was HIV positive and didn't disclose it. This turns the ritual into a massive risk for spreading HIV in a country with already high infection rates, about 9% of adults.
Aniva was arrested after the report, on the orders of a Malawian president, Peter Mutharika. Potential charges mentioned were defiling children and exposing them to HIV. The presidential spokesman condemned it as harmful and despicable evil.
The document includes an update from The Guardian reporting Aniva's conviction for engaging in harmful practices, apparently the first case of its kind. He faced up to 5 years in jail.
Prosecutors argued he was likely responsible for spreading HIV. His defense lawyer argued against jail time, saying the publicity was enough punishment. Aniva himself apparently expected a suspended sentence.
The court explicitly stated that sexual cleansing violates the dignity of widows. The report noted Aniva claimed to have had sex with at least 104 women and girls, some as young as 12, for about $4 to $7 each time.
His wife Fanny is quoted saying she hates what he does, but it brings in needed money. Crucially, she says she doesn't want her own daughter to go through it and wants the tradition to end, stating women are forced to sleep with the hyenas.
Even Aniva himself, despite apparently still performing rituals sometimes, is quoted saying he wouldn't let his own daughter do it and claims he's now fighting against the practice. It suggests maybe some change is happening, even if slowly.
This Malawi case study, as presented, is just a brutal illustration of deeply problematic customary practices, their devastating impact, the clash with human rights, and the slow process of change in state intervention.
Yeah. Following these case studies, the document briefly circles back to customary law. The Malawi example, despite the eventual state intervention, shows these practices can persist.
It notes the intervention came after the bad publicity, but also hints that maybe attitudes are slowly shifting from within, based on what the people interviewed said.
The document then points to an essential reading by Ann Naim about state responsibility under international human rights law to change problematic religious and customary laws. This really highlights that difficult question. What is a state's obligation to step in when cultural or religious practices violate human rights?
It raises that fundamental issue. What authority does customary law have, especially when it directly conflicts with universal human rights?
And the document implicitly asks why understanding customary law is important for a human rights lawyer or activist. It suggests you need to navigate that tension respecting customs while upholding individual rights. You can't just ignore it.
The summary for this part reinforces that women's rights are part of human rights, essential for dignity and reducing poverty. It acknowledges women face structured disadvantages globally and that protecting them involves complex social change.
And a key takeaway from that summary is the need for sensitivity. Human rights advocates need to engage in constructive and sensitive cross-cultural dialogues, rather than being high-handed, to try and break down resistance and empower women effectively.
Okay, now we turn to the main event, really. The major treaty specifically addressing women's rights, CEDAW. Let's repeat the full name and acronym. The Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW.
Right. CEDAW came about largely thanks to the work of the Commission on the Status of Women, the CSW, which was set up way back in 1946. Initially, it was just a subcommission, but its role grew as the UN realized that the existing general treaties weren't really doing enough to effectively promote women's rights in practice.
So the CSW developed documents on women's rights, leading to a declaration on the elimination of discrimination against women in 1967. But being a declaration, it wasn't legally binding, right? It was more aspirational.
Exactly. It was a statement of intent. But awareness of the sheer scale of discrimination grew in the early 70s, leading the CSW to push hard for a proper binding treaty. And that led to CEDAW being adopted in 1979.
The document highlights CEDAW's preamble, which importantly links it back to the UN Charter's ideas of dignity and worth and the Universal Declaration's prohibition of discrimination.
Yes, and the preamble makes that crucial admission right up front. Despite states agreeing to earlier standards like the UDHR and the covenants, extensive discrimination against women continues to exist. It acknowledges the gap. This means women weren't fully enjoying human rights or participating equally despite the existing laws.
The preamble also links the fight for women's rights to broader global struggles against things like apartheid, all forms of racism, colonialism, neocolonialism, aggression, foreign occupation, and domination. It puts women's rights in that wider political and economic context.
It also nods to state sovereignty and links progress to self-determination, which makes sense given the historical context of decolonization when it was drafted.
And the preamble specifically mentions women's great contribution to the welfare of the family and to the development of society, a contribution it says hasn't been recognized enough.
It highlights the social importance of maternity, but also the role of both parents. And crucially, it states this special role shouldn't be used as a basis for discrimination against women.
And it stresses that child-rearing needs shared responsibility between men, women, and society as a whole. The burden shouldn't just fall on women.
Which leads to a really key and sometimes contentious point in the preamble. Achieving full equality requires a change in the traditional role of men as well as the role of women in society and in the family. The document notes this explicit aim of changing traditional roles can clash directly with cultures seeking to preserve those very roles. This highlights a major tension the convention has to navigate.
Okay, let's dive into these specific articles of CEDAW now, starting with Part 1. Article 1 gives the core definition of discrimination against women.
Yes, this definition is vital. It sets the scope. Let's repeat it carefully. Any distinction, exclusion, or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field.
That is a really broad definition. It covers things done on the basis of sex, includes discrimination based on marital status, and by using effect or purpose, it clearly covers both direct and indirect discrimination, as we discussed earlier. It applies across basically all fields of life.
Absolutely. Then Article 2 outlines the core obligations for states that ratify CEDAW. Let's repeat. Article 2 of CEDAW. States have to take concrete steps. They must incorporate the principle of equality into their laws, use sanctions if needed, make sure public authorities act without discrimination, and importantly, repeal discriminatory laws and work to abolish discriminatory customs and practices.
Article 3 builds on that, requiring all appropriate measures to ensure the full development and advancement of women so they can exercise their rights on an equal footing with men.
Article 4 is an important clarification. It says temporary special measures aimed at achieving actual equality, like affirmative action, are not considered discriminatory. However, these measures shouldn't lead to unequal standards permanently. They should stop once equality is achieved. It also clarifies that special measures to protect maternity are allowed and not discriminatory.
Article 5 then puts a really significant duty on states, one that goes beyond just law into culture. Let's repeat. Article 5 of CEDAW.
Yes, Article 5 requires states to modify social and cultural patterns of conduct for both men and women. The specific goal is to eliminate prejudices, customs, and practices based on ideas of inferiority or superiority of either sex or on stereotype roles. This is where the convention directly challenges those ingrained social norms and traditional roles we talked about. It also requires family education to promote maternity as a social function and stress shared responsibility in child rearing, always putting the child's best interests first.
So Article 5 is saying states have to actively work to change not just laws, but attitudes, stereotypes, and cultural practices. This is clearly where clashes with traditional views are most likely, isn't it?
Indeed, that's often the toughest part. Article 6 is shorter but deals with serious issues. States must take measures to suppress trafficking in women and the exploitation of prostitution. Let's repeat. Article 6 of CEDAW.
Okay, moving to Part 2. Article 7 covers political rights and public participation. Let's repeat. Article 7 of CEDAW. States must ensure women can vote, be elected, participate in policymaking, hold public office, and participate in NGOs involved in public life, all on equal terms with men.
Article 8 extends this to the international stage, requiring equal opportunity for women to represent their governments internationally and participate in international organizations. Let's repeat. Article 8 of CEDAW.
Article 9 deals with nationality. Let's repeat. Article 9 of CEDAW. Equal rights to acquire, change, or keep their nationality. Marriage or a husband changing nationality shouldn't automatically affect a woman's nationality, and equal rights regarding their children's nationality, too.
Part 3 then moves into economic and social rights. Article 10 focuses on education. Let's repeat. Article 10 of CEDAW. It lists a whole range of requirements for equal opportunity in education. Things like equal access to career guidance, schools, facilities, teachers, curricula, grants, sports. The list is long.
And Article 10 explicitly requires states to work to eliminate stereotyped concepts of male-female roles in education, encourage coeducation, revise textbooks, and adapt teaching methods.
It also addresses practical issues like reducing female dropout rates and organizing programs for those who leave early, and it includes access to family planning information as part of education.
Article 11 is all about employment rights. Let's repeat. Article 11 of CEDAW, it restates the non-discrimination principle for work and calls the right to work an inalienable right of all human beings, vital for independence.
It specifies protections like equal selection criteria, right to choose profession, promotion, job security, benefits, equal pay for equal work, social security, safe working conditions, all explicitly mentioned.
Article 11 also has specific protections around pregnancy and maternity, prohibiting discrimination based on pregnancy or maternity leave, requiring supporting social services like childcare to help combine family and work, and providing special workplace protection during pregnancy.
And the document rightly notes that historically, keeping women out of work or limiting their jobs was a key way to maintain their subordinate status. So these protections are crucial.
Article 12 covers healthcare. Let's repeat. Article 12 of CEDAW. It guarantees equal access for women and men, including family planning services.
And it requires appropriate services in connection with pregnancy, confinement, and the postnatal period, including free services if needed, and adequate nutrition during pregnancy and breastfeeding.
The document elaborates on why specific health needs are recognized for women, biological factors around reproduction, higher risk of STDs, but also socioeconomic factors like exposure to violence.
Sexual abuse vulnerability is mentioned, leading to harm and unwanted pregnancies. Harmful traditional practices like FGM carry huge risks.
The document also notes women might face barriers seeking medical advice on sensitive issues like contraception, abortion, or violence due to stigma or lack of privacy.
Article 13 covers economic and social life more generally. Let's repeat. Article 13 of CEDAW. Equal access to family benefits, bank loans, credit, and participation in cultural life and sports.
The document finds this article somewhat underdeveloped, especially on access to financial services like loans and credit, which are so important now for women entrepreneurs. It suggests this might reflect the time it was drafted and could be stronger.
Article 14 specifically focuses on rural women. Let's repeat. Article 14 of CEDAW. This article acknowledges the particular problems faced by rural women and their significant roles in family survival, especially in unpaid work.
States must fight discrimination in rural areas, ensure women benefit from development, and encourage their participation in planning. It repeats education rights, but adds specifics like enabling self-help groups and co-ops for economic opportunities.
And it repeats the call for access to agricultural credit, loans, marketing technology, and equal treatment in land reform, plus ensuring adequate living conditions, housing, sanitation, water, transport, communications.
This article really goes into detail on the specific, multiple challenges rural women face.
Okay, moving to Part 4 of CEDAW, which addresses legal and social status. Article 15 covers equality before the law. Let's repeat. Article 15 of CEDAW.
Article 15 guarantees women equality with men before the law. Paragraph 2 is key. It requires states to give women identical legal capacity in civil matters. That means equal rights to conclude contracts, administer property, and equal treatment in court procedures.
It also states that any contracts or private legal documents that try to restrict women's legal capacity are null and void, and men and women must have the same rights regarding movement, residence, and choosing where they live.
The document really stresses how central this guarantee of legal capacity is. It calls it perhaps the essential human right, linked directly to being recognized as a person with rights. To be deprived of legal capacity is basically to become rightless.
Exactly. Article 16 then applies this legal capacity concept specifically to marriage and divorce. Let's repeat. Article 16 of CEDAW. States must eliminate discrimination here, too, ensuring equal rights to enter marriage only with free consent and the same rights and responsibilities during marriage and when it ends. Dissolution.
This includes rights over children, regardless of marital status, covering guardianship, adoption, etc.
And the last paragraph of Article 16 is interesting. It links women's rights to children's rights by stating that the betrothal or marriage of a child has no legal effect. And it requires states to take action, including passing laws, to set a minimum age for marriage and make marriage registration compulsory. This is a direct tool against child marriage.
Right. Now, Part V of CEDAW shifts gears to the institutional side, the enforcement mechanisms. Article 17 establishes the Committee on the Elimination of Discrimination Against Women. Let's repeat. Article 17 of CEDAW, establishing the CEDAW Committee.
Yes, the CEDAW Committee. It's made up of experts elected by the state's parties, serving in their personal capacity, with an eye towards geographical balance and representing different legal systems.
And Article 18 details the committee's main job, considering the reports submitted by states' parties on how they're implementing the convention and the progress they're making. Let's repeat. Article 18 of CEDAW on state reporting.
So a key mechanism is the state reporting process. Countries have to periodically report back on what they've done.
Article 21 outlines the committee's duties based on these reports. Let's repeat. Article 21 of CEDAW. It reports annually to the General Assembly, making suggestions and recommendations based on the state reports. Its reports also go to the Commission on the Status of Women, CSW.
Article 22 allows specialized UN agencies like WHO or UNESCO to report to the committee as well, adding outside expertise. Let's repeat. Article 22 of CEDAW.
Part 6 has technical stuff. Article 29 mentions a dispute resolution process between states involving arbitration or the International Court of Justice, but the document notes this is subject to many reservations and has actually never been used.
Now, the document makes a really important point about CEDAW's substance. It suggests that technically, CEDAW might not add a huge amount of completely new legal obligations for states that were already signed up to the ACCPR and ICSCR because those treaties already prohibit sex discrimination generally.
That's a key point. Let's repeat that. CEDAW's real importance, according to the document, might be less about creating brand new rights from scratch and more about its allocation of attention, resources, and expertise specifically to issues affecting women. It gives these issues dedicated focus.
Exactly. But it also notes that human rights treaties evolve through interpretation. CEDAW provides a crucial forum for developing innovative interpretations and applying rights specifically to women's issues in ways that might not happen in the general treaty bodies.
This evolution is vital. The document notes CEDAW is unique in having civil, political, economic, social, and cultural rights all supervised by one specialist committee, allowing a holistic view.
Beyond state reporting, CEDAW got more teeth later with an optional protocol, the OP. Let's repeat.
Yeah.
The optional protocol to CEDAW.
This came much later, adopted in 1999, entering force in 2000, 20 years after the convention itself. The document suggests the delay might be because CEDAW was initially seen more as an economic and social rights treaty, which usually only had reporting mechanisms.
Yeah, the OP's adoption reflects a growing understanding that the distinction between civil, political, and economic social rights is often artificial, and all rights can potentially be subject to quasi-judicial scrutiny.
So the OP introduces two main procedures. Article 2 allows the committee to receive and consider communications, basically complaints from individuals or groups claiming to be victims of violations of the convention. Let's repeat. The communication procedure under the optional protocol.
Right. So individuals can complain directly to the committee if their state has ratified the OP. Article 3 says communications must be written, not anonymous, and only from state's party to the protocol.
Article 4 then lays out the admissibility criteria, the hurdles a complaint has to clear. Let's repeat. Article 4, the optional protocol. A big one is exhausting available domestic remedies. You usually have to try the national courts first.
But there are exceptions if domestic remedies take too long or are unlikely to actually work.
Other reasons a case might be inadmissible include if it's already been looked at internationally, if it's incompatible with CEDAW, if it's clearly baseless, an abuse of the right to complain, or if it concerns things that happened before the state joined the OP unless the violation continued after.
Article 5 gives the committee power to request interim measures from the state to prevent irreparable damage to the victim while the case is considered. This is an important protection, applicable once the case is deemed admissible.
Article 6 requires the complainant's consent to reveal their identity to the state. The state then gets 6 months to respond in writing, explaining the situation and any remedy provided.
Article 7 stresses confidentiality. Article 7(4) says after the committee gives its views, the state has 6 months to respond detailing actions taken.
The second procedure in the OP is the inquiry procedure under Article 8. Let's repeat. The inquiry procedure under the optional protocol. This allows the committee to initiate an inquiry if it gets reliable information about grave or systematic violations by a state party.
This is a bigger deal. It could even involve a visit to the country itself. The findings are sent to the state, which has 6 months to respond.
But Article 8.5 notes these inquiries are confidential and require state consent for the inquiry and any visit. Article 9 deals with follow-up reports. Article 10 allows states to opt out of the inquiry procedure when they ratify the OP.
And Article 11 requires states to protect people who communicate with the committee from any ill treatment.
So the optional protocol significantly strengthens CEDAW enforcement with these individual complaints, communication procedure, and investigations into serious patterns of abuse, inquiry procedure, but only for states that agree to be bound by the protocol.
Beyond CEDAW and its OP, the document mentions other mechanisms that help. The creation of the post of Special Rapporteur on Violence Against Women in 1994 by the Commission on Human Rights is one example. Let's repeat that. Special Rapporteur on Violence Against Women.
Right, an independent expert focused just on that issue, gathering information globally. Another layer of monitoring.
And it also reminds us that mechanisms under other treaties can be used, like the first optional protocol to the ICCPR, allowing individuals to complain about violations of Article 26, that standalone non-discrimination clause.
The case of Brooks v. Netherlands is mentioned here as an example. Let's repeat that case name. Brooks v. Netherlands.
Yes, in Brooks v. Netherlands, a Dutch Unemployment Benefits Act was successfully challenged under ICCPR Article 26 for discriminating against women. The Human Rights Committee's decision was apparently so controversial that the Netherlands even thought about leaving the ICCPR and its protocol.
Wow. It shows that gender discrimination can definitely be tackled using general non-discrimination rules in other treaties, not just CEDAW.
Violence or discrimination might also fall under other specific conventions, like the Race Convention or the Convention Against Torture, although the document says those are examined later.
Okay. The document then turns to state attitudes towards CEDAW and how it's interpreted. It starts with a really striking fact. More states have made reservations to CEDAW than any other human rights treaty.
That's a huge statement. And it's not just the number, but often how broad these reservations are. The document gives examples. Brunei Darussalam reserving anything contrary to its constitution and Islam. Oman reserving anything not aligned with Islamic Sharia and national law. Pakistan signing on subject to its constitution.
This raises a really critical question, posed right in the document. Have these states actually accepted any real legal obligations by joining CEDAW with such sweeping reservations? Can you really be bound by a treaty if you reserve the right to ignore parts that conflict with your existing laws or beliefs?
And what does this tell us about the level of resistance to women's rights at the state level? It shows that signing a treaty is one thing, but truly committing to implement it, especially when it challenges established norms, is quite another.
But despite these challenges with reservations, the document says CEDAW has been interpreted in really useful ways by the committee. General Recommendation 19 on Violence Against Women from 1992 is highlighted as a key example. Let's repeat. General Recommendation number 19 on Violence Against Women.
Yeah, as we noted, CEDAW itself doesn't explicitly mention violence against women. Violence affecting physical integrity might fall under torture and human treatment bans in other treaties like ICCPR Article 7.
But General Recommendation 19 was groundbreaking because the CEDAW Committee interpreted gender-based violence as being a form of discrimination under Article 1 of CEDAW.
This was a major interpretative leap. The committee argued that because gender-based violence impairs or nullifies women's enjoyment of human rights, it is discrimination under Article 1. It then listed specific rights from other treaties that violence against women impacts right to life, freedom from torture, equal protection, equality in the family, health, work.
And GR19 explicitly linked violence against women to specific CEDAW articles, Articles 2, 3, 5, 6, 10, 11, 12, 14, and 16. That's 9 articles connected to violence through this interpretation.
It also provides 22 detailed recommendations for states to tackle violence. For instance, states should prevent coercion around fertility reproduction and ensure women aren't forced into unsafe procedures like illegal abortions due to lack of services.
The document notes that implementing this might require states to challenge customs, decriminalize abortion in some cases, ensure access to family planning info, and make healthcare accessible.
And the document argues strongly that without CEDAW and the committee's focused work like GR19, this level of detail on violence against women, especially focusing on private violence and reproductive rights, probably wouldn't have emerged from the general treaty bodies. It really shows CEDAW's unique value.
The document does include a section on feminist criticisms of CEDAW and other human rights treaties. It's important to hear these critical voices, too.
Yes, some feminist scholars have critiqued the whole system. Criticisms of the Universal Declaration include things like Article 16's definition of the family.
Criticisms of the ICCPR often focus on its reporting system not being great at picking up specific violations of women's rights.
And criticisms of CEDAW itself include the argument that it has potentially led to a ghettoization of women's rights issues.
Ghettoization. That's a strong word. The idea being that putting women's rights in a separate box keeps them from being fully integrated into mainstream human rights.
Sort of, yeah. That they become siloed off, seen as a separate issue rather than fundamental to all human rights. Furthermore, the document notes criticisms that CEDAW's enforcement mechanism has been seen as relatively poorly funded compared to other human rights bodies.
The document asks if these criticisms are fair, noting it's complex to assess without detailed study of reporting practices, budgets, and considering things like gender mainstreaming efforts across the UN.
And the reference to Nussbaum's work suggests some feminist views see international law, including CEDAW, as maybe lagging behind the women's movement, but still a useful tool nonetheless.
Okay, the document then concludes with 2 case studies looking at how states parties engage with CEDAW, Singapore and Nigeria. These are meant to illustrate practical problems and approaches, not necessarily representative of everyone, but highlighting common challenges.
Let's start with Singapore. Let's repeat. Singapore and CEDAW. Singapore ratified in 1995, submitted its 5th report in 2015, considered in 2017.
The report highlights Singapore's multicultural, multi-religious nature, Chinese, Malay, Indian groups, Buddhism, Christianity, Islam, Taoism, Hinduism. This influences its legal system, which has both civil law for non-Muslims and Muslim law under ALA for marriage and divorce.
So you have these 2 parallel legal systems for family matters. The Constitution guarantees equality, and policy emphasizes equal opportunity based on merit.
Singapore's reports detail legislative and policy efforts, often emphasizing an evolutionary and progressive approach, especially regarding the Muslim minority and personal laws under MLA.
This has apparently been a point of discussion with the CEDAW committee. Singapore has strengthened state oversight of religious affairs, setting up MUI, an independent body of Muslim scholars, to monitor and recommend ways for Muslim practices to remain progressive.
And this links directly to Singapore's reservations to CEDAW. They partially withdrew reservations to Articles 2 and 16 in 2011, but kept specific reservations to allow Muslim law under MLA to operate, even if it conflicts with CEDAW.
The example given is polygamy under AMA, which is only allowed for men. Applications are reviewed, there are requirements, and the first wife has rights to object or seek divorce.
As a result, the document notes, only a tiny fraction of Muslim marriages in Singapore from 2009-2014 were actually polygamous, maybe 1 in 300.
The CEDAW committee's comments over 20 years show an ongoing dialogue. There's been progress, but CEDAW remains concerned about inequities like polygamy only being for men.
But the document raises a fascinating point. What if the law allowed polygamy for everyone equally? Would CEDAW object? It suggests maybe not, as CEDAW focuses on non-discrimination equality, not necessarily the substance of practices like polygamy itself, as long as it's applied equally. A subtle point about the committee's role.
Now let's look quickly at Nigeria. Let's repeat. Nigeria and CEDAW. Nigeria ratified CEDAW back in 1985 and the optional protocol in 1999. CEDAW looked at its 7th and 8th reports together in 2017, highlighting reporting delays.
Many issues raised by CEDAW regarding Nigeria are recurring ones, indicating ongoing challenges. The rise of Boko Haram is mentioned as a more recent major challenge.
CEDAW noted some advances in Nigeria's 2017 report laws against FGM, child marriage, violence, HIV discrimination, efforts to improve institutions.
But deep concerns remained about the tripartite legal system and governance issues hindering implementation. Nigeria has Islamic Sharia law, customary law, and common law all operating. Let's repeat that. Tripartite legal system, Sharia, customary, common law.
This historical setup makes common standards incredibly difficult. The Constitution prohibits discrimination, but many states stick to traditional gender roles that CEDAW sees as discriminatory.
There are inconsistencies even within traditions. Some Sharia provisions clash with CEDAW, others don't, like a Zamfara state law punishing trafficking in women.
Customary law practices in the South, like widowhood rights and inheritance, remain discriminatory. Social attitudes worsen these problems, though CEDAW noted film TV might help challenge stereotypes.
Though not stressed in the 2017 summary, the document mentions CEDAW's past concerns about property rights in Nigeria. Back in 2004, an estimated 90% of registered land was in men's names.
Property rights are tangled up in the tripartite system, lack of awareness, social exclusion. Some southern states didn't allow women to own land. Under some customary laws, wives were seen almost as slaves, and many widows in the southeast lack protection and have rights abused.
Interestingly, under Sharia law in some northern states, widows seem to have more rights, a compulsory mourning period, and rights to inherit property alongside children.
So paradoxically, Sharia law, while problematic in some areas from a CEDAW perspective, appears to offer better protection for widows' inheritance rights than some customary laws elsewhere in Nigeria. It's complex.
The document concludes that by allowing this tripartite system, respecting community demands, Nigeria often undermines individual rights, especially women's. It calls it an undeniably difficult balance to strike.
Yeah, the Singapore and Nigeria case studies really show how diverse national contexts, legal setups, cultural factors, and state engagement create very different pictures for CEDAW implementation. Progress and persistent challenges exist side by side.
We talked about violence against women earlier with CEDAW's General Recommendation 19. The document now focuses specifically on the Declaration on the Elimination of Violence Against Women. Let's repeat. Declaration on the Elimination of Violence Against Women.
Right. Adopted by the General Assembly in 1993, this declaration complements CEDAW, which didn't explicitly condemn violence, although its principles covered it.
It was felt necessary to build on existing work and make a clear statement against this widespread problem. The resolution calls violence against women a manifestation of historically unequal power relations and a crucial social mechanism forcing women into subordination.
The declaration stresses violence is pervasive, cutting across lines of income, class, and culture. Though some groups are especially vulnerable minorities, indigenous women, refugees, rural women, disabled women, elderly, women in conflict, girls.
Article 1 gives a broad definition of violence against women. Let's repeat. Article 1 of the Declaration on the Elimination of Violence Against Women. It defines it as any act of gender-based violence that results in, or is likely to result in, physical, sexual, or psychological harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or in private life.
That's a really wide definition: physical, sexual, psychological harm, threats, coercion, loss of liberty, and crucially covering both public and private life. That brings domestic violence clearly into scope.
Article 2 expands on this with examples. Let's repeat. Article 2 of the Declaration. Paragraph 1 lists violence in the family: battering, sexual abuse of female children, dowry violence, marital rape, FGM, other harmful traditions, non-spousal violence, exploitation.
Paragraph 2 covers violence in the general community: rape, sexual abuse, sexual harassment, and intimidation at work, school, elsewhere. Trafficking, forced prostitution, including harassment and intimidation, is significant.
So the document interprets this as saying forced prostitution is violence, but maybe not necessarily consensual prostitution.
And paragraph 3 covers violence perpetrated or condoned by the state, holding the state accountable for its actions or inaction.
Article 4 is critical for state obligations. Let's repeat.
Right.
Article 4 of the Declaration. States should condemn violence and not use custom, tradition, or religious consideration to avoid their duty to eliminate it.
This directly challenges those justifications we saw earlier, and it requires states to exercise due diligence to prevent, investigate, and punish acts of violence against women, whether perpetrated by the state or by private persons. This includes legislation, research, policy.
Article 5 calls for international cooperation via the UN to coordinate programs against violence.
And Although the Declaration itself doesn't have an enforcement body, it's not a treaty, the document notes the later appointment of the Special Rapporteur on Violence Against Women helps fill that gap somewhat, providing monitoring and advocacy.
Okay, wrapping up. The document summary ties everything together. It suggests a defining feature of women's rights has been their relative subordination to the supposedly more universal idea of human rights.
Why is that? Why wasn't the International Bill of Rights enough? The document suggests a few reasons. Maybe the UN initially downplayed women's rights, maybe enforcement mechanisms remain weaker, and crucially, pervasive patriarchal cultural attitudes resist change.
While acknowledging CEDAW, its OP, the Declaration on Violence, and the Special Rapporteur are major steps, the document stresses a great deal must still be done.
It mentions further reading on CEDAW as holistic, critiques of ghettoism, but is still useful.
And it ends with that sample exam question. Women's rights or human rights? Discuss. Bring us full circle.
The advice on answering confirms the complexity. You can agree broadly, citing documents like the CEDAW preamble or the Vienna Declaration that explicitly link them.
But you also must account for the weaknesses, the relative lack of protection historically, the absence of specific rights for women's harms in the original Bill of Rights. This suggests women's rights were treated as something a little less than the universal rights of man.
You'd use feminist critiques here, details on CEDAW enforcement issues, reservations, states not signing the OP.
Ultimately, positive developments have to be weighed against those deep resistances to recognizing the full and equal humanity of women present in patriarchal cultures throughout the world.
This deep dive really has taken us through the foundations of discrimination and equality, how treaties handle them, the specific context of women's rights, the whole CEDAW framework, the challenges, interpretations, and those vivid case studies from Kenya, Malawi, Singapore, Nigeria.
It's been a truly extensive look at a vital and, well, incredibly complex area of human rights law.
Yeah, understanding those nuances, non-discrimination versus equality, the treaty differences, the specific challenges women face, CEDAW's structure, it's essential.
And seeing how culture and national law intersect with international standards, like in the case studies, really brings it home, doesn't it?
Absolutely. It highlights that human rights aren't just abstract ideas. They involve really difficult, real-world efforts against ingrained inequalities and harmful practices.
We really hope this deep dive into these documents, generously made available by the University of London for educational purposes, has been incredibly helpful for your understanding and, well, for your studies.
This deep dive was brought to you by Sinorbit Academy, Sri Lanka.
Keep exploring these ideas. That tension between universal rights and cultural practices, the fight against discrimination and violence, the work still needed for true equality loads to think about.
Definitely. We wish you the very best of luck with your studies and your exams. Keep digging deeper. And maybe consider this challenge raised by the document. If achieving full equality really does require changing traditional roles for both men and women, and given the cultural resistance to that, how can international human rights law actually drive that kind of fundamental social change without just being seen as imposing outside values? It's a tough one.
That's all for this deep dive. See you next time.